We are now live, Chair.
Thank you. Good morning, everyone. Welcome to today's hearing of Cheap Meals, 146 Uxbridge Road, West Ealing, London W13 8SB. And it's a virtual hearing on the 1st of November 2023. My name is Councillor Amarjit Jemu, and I shall be chairing the meeting. My colleagues, Councillor John Martin and Councillor John Ball, and I comprise of today's subcommittee. Cornelia Harding, who is the clerk to the subcommittee, will be minuting the meeting. Alison Love is the legal advisor to the subcommittee. In accordance with the procedure, I will invite the applicant to present the application, answer any questions, and call any witnesses. I will also invite those who've made representations, objections to make their representations, answer any questions, and call any witnesses. At the conclusion of the hearing, the subcommittee, accompanied by the legal advisor and the committee democratic services officer, will retire to consider its decision. The decision will be given at the end of the meeting. And the panel, if the panel cannot reach a decision today, you'll be notified in writing within 5 working days. Okay, welcome everybody. I would like to ask those present who are intending to speak to introduce themselves, please.
I'll go first. Hello, I'm Shane Elliott from Licensing at Ealing Council.
Thank you.
Good morning, everyone. Mimi Stupa from the Noise and Nuisance team.
Thank you, Mimi.
Good morning, Chairman, to you and your colleagues. My name is Sarah Clover. It's Miss Clover. I'm a barrister, and I'm here to make the application on behalf of Cheap Meals this morning.
Thank you, Miss Clover.
Sami Akbari, Cheap Meals manager. Sorry if I interrupted somebody.
Thank you.
Good morning all. Yasin Alam, I'm the head of operations of Cheap Meals, also supporting Sami in the application.
Okay, thank you. Miss Clover, I see a hand raised. Is that yourself who's raised the hand, or is it my screen that's playing up?
Madam Chairman, I literally put my hand up just to indicate I would speak. I haven't done anything else.
Okay, thank you very much. Okay, now I am going to be introducing the report, and then we can start from there. Okay, here it is, the process. You will have all received or seen the agenda pack, within which is contained the licensing officer's report with details of the application in section 1.0. To confirm, we are dealing with the application for a new premises license made by 146 Cheap Meals Group Limited relating to Cheap Meals, 146 Uxbridge Road, Ealing W13 8SB. We note there have been several written representations objecting to the application from responsible authorities and one interested party. In addition, the Metropolitan Police have suggested hours and conditions should the premises license be granted. Okay, in accordance with the procedure now, I shall invite the applicant to present the case.
Madam Chairman, thank you very much indeed. I'm going to start with a positive application, if I may, although I'm obviously aware that there have been some objections and some concerns raised, and I will deal with those in a moment. But I would like to commend this application to you, first of all, on a positive note, because it's one of the features of this application that it's a positive contribution to the local economy, that the business has been there for a little while. Sami Akbari, who you've been introduced to, is here with us today as the manager of the store. Yassine Alam, also with us today, is the head of operations for Cheap Meals. And this is a smallish company that is starting to expand and is starting to do rather well. There are 11 branches of Cheap Meals throughout London, and there is still some growth on the horizon. Mr. Hekmat Bavary is the Chief Executive Officer. He's got quite a considerable amount of experience of licensed premises, both with and without alcohol. Cheap Meals, as the fast food enterprise, obviously has no alcohol, and that's an important consideration for you. Overall, the premises, the organisation is employing something like 240 employees. At this particular store, I think there are around 12 members of staff, and Mr. Akbari leads. And I'm going to talk in a little while about the experience of those at the store and the communications with the officers, because I think there's been some concern there. I can deal with that, but I just wanted to introduce you to the business to start with. Cheap Meals produces fast food, but it's intended to be premium fast food. So they do, it's high quality. So I don't know if you've sort of come across that end of the market. It's trying to distinguish itself perhaps from some of the lower quality offerings. Burgers, wings, hot dogs, shakes, that kind of thing. And it's for eating, so customers are welcome within the requisite hours to sit in the restaurant and eat, as well as to walk in and take away their meals and move on. And there's obviously also quite an important delivery element, and that's fundamentally important to the premises. Something that changed, a phenomenon that changed over the pandemic. People's habits changed somewhat to access delivery services, and that's become a more ingrained part of our culture now, and it's become a very important element for food providers. You've probably seen advertisements on the television about deliveries, and you can have what you want at any hour of the day and so forth. That's become an important part of our late night economy, and these premises need to be able to access that as well. They have a close relationship with delivery partners, and by delivery partners I mean the sorts of people who advertise on the television, and those delivery partners also have to have an element of control over their drivers, because the sorts of concerns that you might be thinking of in this application are replicated across the entire nighttime economy. What do we do when drivers park badly, or perhaps they're noisy, or perhaps they're not considerate of their neighbours and so forth? These are not isolated problems that might pertain to this particular application. It's something that has to be considered across the nighttime economy. So the delivery partners have provisions in place, disciplinary provisions in place, in case there are complaints about drivers, and also outlets like Cheap Meals don't want that kind of negative behaviour because it impacts on them, their licence, their reputation. So they have that dialogue with the delivery partners, and if they have any particular issues with drivers, they will pass that on. The drivers are either disciplined, they're not permitted to come back to the store and so forth. There's quite a tight control regime there, which we would be happy to talk about further if required. Where they can park, where they wait for food, that kind of thing is very much tightly controlled across the board, and also at this store. We have to remember that this store is entitled to open until 11 o'clock at night. You will know that late night refreshment is one of those funny quirks of the Licensing Act 2003. You only need a license between 11 o'clock at night and 5 o'clock in the morning. So this application, it was until 3 o'clock in the morning across the board, and we'll talk about the conciliation that's taken place with the police, which is very positive, very important, and the premises are now very happy to accede to the position of the police and the hours that the police want. Which is for eating in through the week, Sunday to Thursday until midnight. So it's just a 1 hour extension for eating in through weekdays, and a 2 hour extension on Fridays and Saturdays till 1 o'clock. And so the 3 o'clock extension then only applies to pick up, walk-in takeaways, and the deliveries. And the police were content with that, subject to a certain number of conditions. You will have the conditions that were submitted as part of the application on page 18 of your agenda, and the police have supplemented those. And you'll have those within their representation. And I won't read them through laboriously because you can obviously read those through and go through them for yourselves, but they match what was offered in any event. The police want conditions about good quality CCTV and notification if something goes wrong with that CCTV. They want good quality training provided for the staff to make sure that they know how to manage conflict if it arises, and that they will liaise with the police and the authorities where required. They keep records for that the authorities can check. Notices, just to remind everybody, delivery drivers and customers, how they should be behaving in an area that does have some residential accommodation. No children after 11 o'clock, and deliveries, collections dealt with appropriately, expeditiously, incident logs, that kind of thing. It's fairly standard, I have to say. These are the sorts of conditions that a Cheap Meals Outlet would be putting forward anyway. Very happy to agree those with the police. The important element of the conditions is not only to control the licence that these premises would have, but I'd also invite you to consider that the impact that those conditions have on the location in general at the later hours, if there are concerns about antisocial behaviour, misbehaviour of anybody, including delivery drivers, people getting up to activities that they shouldn't be getting up to. Having that kind of extended vigilance with CCTV cameras pointing and trained members of staff being observant, all of those things, child exploitation issues, vulnerable persons issues, all of that kind of thing. Having active premises slightly later into the night can actually assist with all of those issues and can actually drive down negative behaviour in a locality rather than the reverse. You're going to hear in a moment that the premises actually have been trading to the later hours that they wanted, and that's been a crossed wire, that's been a misunderstanding, and I will explain a little bit more about that in just a moment, because you will have seen that within the representations of both Mr. Elliott and Ms. Stupu. It's important to comment on that your job, your remit today is to consider the application and any impact that the application might have on the licensing objectives. Despite the fact that the authorities might have been disgruntled by anything that has happened so far, although when I explained it to you, I think it is more of a crossed wire situation. This isn't an opportunity to mete out a penalty or a punishment. That can be done if it is required through the courts, through the magistrates' courts, and that's set out within the Licensing Act 2003. The consideration for today is whether there should be premises license here and any impact that the application would have on the 4 licensing objectives. And those are the only considerations for this committee. Ms. Stupu has also mentioned something about an extractor fan, and again, although I will deal with it, that would not, and she's quite fair to raise this in her representation, that does not fall within today's consideration, because it falls under different legislation and it falls outside of the requirement to look at the application and the 4 licensing objectives. So the fact that the premises have actually been trading to a later hour, whether that was the correct approach or not, is still a good acid test as to what kind of impact that would have to those later hours. Does it attract a trouble element? Are people congregating? Are people being disturbed by delivery drivers? So there has actually been an opportunity to see those potential impacts in action, and they have not occurred. And that will in part be down to the operation of the premises, the conditions, and so forth. So just to come back to the police objection, you may very well know under the Section 182 guidance, I think it's paragraph 9.12, the committee are invited to take the advice of the police as the professional responsible authority with remit for crime and disorder as to whether the application will have a negative impact on the licensing objectives generally, but the impact on crime and disorder specifically. And in accordance with the case law of Thwaites, if the police are satisfied with that position, it would require some element of evidence to demonstrate that the police were wrong for some reason and that the hours and the conditions that they are putting forward would not be appropriate. So that's a good place to start. And the applicant is obviously very pleased to have been able to work positively with the police to secure that position. Unfortunately, it's given rise to the crossed wire. It's given rise to the confusion that has arisen. And the premises and the staff at the premises are obviously very good at what they do. They're not very good licensing lawyers. There was a period prior to the application when the premises were opening too late, and the officer contacted, Mr. Elliott, I believe it was, contacted the store and said, "You're opening too late, you don't have a license yet," which has prompted the application, which is the right thing to do. You cure that situation by succumbing to the regulatory regime and getting that license that is required, and that's what's happened. There was then a period of confusion, unfortunately, and I have the emails here. Mr. Alam, who's quite experienced at putting in applications for cheap meals because he's done it for the other premises, put in a full application to the council, which was the right thing to do. He then got an email back from the council saying, "No, you've done the wrong thing. We require you to put in a minor variation because you have already got a license and you simply need to vary it by adding late night refreshment." Now, that was wrong. It was incorrect information. I think there might once have been a premises license for this unit, which may also have added to the confusion, but it was no longer operative. So it wasn't a minor variation, but Mr. Alam did as he was told, and he withdrew the full application and he submitted the minor variation that he was asked to do. And then he got another email from the council saying, "No, you've done the wrong thing. You need to put in a full application." So he withdrew the minor variation and put in the full application. So you can see that it got off to a bit of a wobbly start with the council. It caused quite a lot of delay. There was about a 3-week delay as a result of that. And even in the emails that were sent out from the council, I think it was Sonia Francis, the email said, "We're in receipt of the attached minor variation application for cheap meals. However, after checking the application, we can accept the minor variation application for the following reasons outlined below." And then the reasons were given as to why they couldn't accept a minor variation. And she said, "You will need to apply for a new premises license." She said, "There is no current premises license for cheap meals, and due to this reason means that there is license to vary." Now, that's a very confusing email. And unfortunately, it's given rise to this baseline. The premises haven't quite known where they were. They then negotiated with the police and got the email from the police that you have seen. And again, there was some element of confusion that meant they could already start to open to the later hours. And so they did. And then they received further correspondence saying, no, you can't start yet. You haven't had the hearing. And so they stopped. And so profuse apologies are offered to the council for this misstep, for starting too soon, effectively. However, I'm here to say two things. Firstly, that in and of itself would not be a reason to refuse the application now as a punishment for getting it wrong to start with. And secondly, it has actually given you and the officers and the residents an opportunity, rightly or wrongly, to see what it will be like when Cheap Meals opens that bit later. And I think that element is quite important, because although you have a representation from the Residents Association, what you don't have is representations from individuals saying, Cheap Meals has been open, I've been able to hear their delivery drivers, I've been disturbed by noise of deliveries or whatever else it might be, and I don't want these premises to open. The Walpole Residents Association representation is written as if the application was prospective, which of course technically it is, and these problems might happen in the future without acknowledging that actually there's been activity on the ground that has not made good the concerns that have been suggested. So that there is that. The other thing to bear in mind is that there are other premises in the locality that do open late, and if the police had already seen elements of concern about antisocial behaviour and congregation and so forth pertaining to those late night takeaways, they would have raised that and said, we don't want any more. We don't want other premises to open to those hours because it causes problems. And so I've got the list of other local late night refreshment premises that are open. Best Mango Grill is open till 5:30, Red Jalapeno until 3, Faraway Pizza until 3, Hab Shawarma Lebanese Grill until 3, and then Bagel Bite and McDonald's at Ealing Broadway are 24 hours. So there is an element of nighttime economy, late night refreshment economy already active in the location that doesn't appear to be causing any particular issues, either that the residents have raised, that there's no mention of those within the Residents Association rep, and the police are certainly not worried enough about anything that's already there to say, and we don't want another one. And that's also a good sign that I would draw to your attention. So just to come then to the two responsible authority representations, it is disappointing that they feel that the premises and the management have not been engaging positively with them. I hope I've put into context the hours misunderstanding, and I would say it is no more than that. And obviously the complete cure for that is a license that covers those hours. But in relation to the slightly sterner criticisms that these are operators that don't respect authority and don't work well with the authorities, that's not correct. And that can be seen through the engagement of Cheap Meals and their operatives with other authorities in other areas. This isn't a one-person band, as it were. This is a small company that has experience and has a management hierarchy of working with the authorities, and you can see that through the email correspondence. And I've got the email correspondence, the whole of the email correspondence, that shows that where the officers have failed to get hold of Mr. Akbari for some reason, Mr. Yassin Alam has jumped in, and he has sent an email, or he's invited email correspondence. So whilst it's true to say that Ms. Stupu had some difficulty contacting Mr. Akbari on the telephone for a period, that's because he was out of the country due to the death of his father, which was obviously quite an emotional and difficult time. But there was then correspondence with Ms. Stupu saying, I'm sorry you've been unable to get Mr. Akbari, would I do? Can you speak to me? By Mr. Alam. The other complication is that Ms. Stupu has not seen it to be appropriate to give her number for somebody to call her. So it always has to be her calling one of the operatives at Cheap Meals, and you'll know perhaps how difficult that is, just to pick a random time of the day and catch somebody who picks up their phone. Obviously, after 2 or 3 attempts at that, she's become frustrated and said, I can't reach anybody. Well, that's not strictly fair, because there have been emails going in the other direction saying, could we have your number so that we can call you? But there have been those, that sort of telephone ping pong type of situation that's gone on. Now, that is not indicative of a reluctance to work with the authorities. That's just miscommunication. And I have the emails here that demonstrate that. Now, Ms. Stupu has also been asked to communicate with Cheap Meals on my advice, because obviously the company instructs me. We've requested the number to call her on. We've requested noise readings from the site visits about the fan extractor. And those have not been provided. We've requested all the site visit notes and the file notes that are held, and I could obtain those under freedom of information if I needed to, and I will if I have to, but they haven't been provided. I've written to Ms. Stupu myself. She spoke to Mr. Alam 2 weeks ago and was invited then to call back, but hasn't to date. And we got a letter yesterday at 7 o'clock in the evening specifically about the fan. So In fairness to my clients, there has been a little bit of to and fro. So to represent that as a refusal to engage with the authorities would not be the correct way of putting it, and I do quite resolutely reject that. The preponderance of Ms. Stupu's representation then relates to this fan. And as I've mentioned before, she does very fairly say, well, actually, although that's the context in which I've been trying to engage with the premises, that belongs to another set of legislation, and that's true. That's the Environmental Protection Act 1990, Section 79, Section 80. And if there are to be proceedings under that act, that would go to a different decision maker, and that would not be the concern of this licensing committee. And again, I need not take you through it, but there are issues relating to that. No nuisance is conceded in relation to that fan, but it is a fact, and I think I can tell you this, that amendments have been made to the fan, alterations have been made to the fan on the recommendation of the environmental health officers. So the environmental health officers have done visits to the premises and says, you want to do this and you want to do that, and it's not this and it's not that. And those changes, or at least to date, some of the changes have been made in accordance with those recommendations, and they haven't worked, or they appear not to have worked. Now, that's not a concession as to whether that constitutes nuisance or not, and we're still in the middle of investigating what further can be done, because there's a landlord at this building, it would require scaffolding to be erected, and so on. So it's a complicated position, but on any view, it's not a Licensing Act position, and so I will draw a veil there. And you've got, again, in the Secretary of State Section 182 guidance, paragraph 1.16, at the fourth bullet point, it very clearly says that the general principles of licensing are that it should not duplicate other statutory requirements. And Ms. Stupu knows that, and that's why she's put it in her representation. However, when you take away those two elements, what's wrong with the fan and disrespect for officers, regulatory officers, having dealt with those 2 points, there's nothing that remains in the representation either of Mr. Elliott or Ms. Stupu that could actually defeat the application based on the 4 licensing objectives today, which is really what we are here for. Just to wrap up then, this is a mixed use area. I think all the officers agree with that. Residents do live above the premises. They don't appear to have a concern with the takeaway operation in and of itself. And I've dealt with Mrs. Chapman and the Walpole Park Residents Association, and I'd be happy to deal further with that. Can I just very briefly ask Mr. Akbari to address you, because having had this concern that he doesn't engage, he doesn't speak to regulatory authorities, just wanted you to hear him on that point. It's sometimes helpful, rather than me doing all the representation, of you to hear the person who will actually be there on the ground. With your consent, Chair, could I ask him just to say a very brief few words?
Thank you, Sarah. Yeah, I just wanted to really highlight that we've had no previous issues with the store operating till late. We've been very cooperative with all authorities. This actually does include Ms. Stupu, who at the very early stages, when I believe she mentioned that there was some nuisance in relation to the fan, I actually, out of my own way, because I was actually off that day, came into the store, which I believe was actually late evening, to meet her in person, to see what we can do and cooperate with her so that the noise levels were reduced. It's also important to highlight as well that the company Cheap Mills has actually invested £3,000, which is quite a significant amount, in actually improving the actual fan and the way in which it actually operates. And in that particular meeting, I mentioned to her several times that, of course, we're here to support the council and to be as supportive as possible to our neighbours. They're very, very important to us, a lot of whom are actually customers of ours. And we really wanted to make sure that anything we could do from our side, we would be happy to do so. And one of the things that she did suggest was the speed at which the fan was operating at. So you have an indicator of 1 to 5, with 5 being the high speed, which typically makes higher level of noise, and 1 being the lowest amount. She suggested if we could leave it at 3, which I accepted, and it has been remained at 3 ever since. Nobody's touched that, and we will touch that for the future because we are very, very considerate of our neighbours. Our job here is not to cause any nuisance or to come off on the wrong side of the stick with our neighbours, because they're very important to us. So very, very cooperative in that side. And also, it's also important to also mention that we've been very, very cooperative with the police up until now as well. A lot of the points that the police have actually highlighted as indicators that they would like us to agree to have already been taken into consideration and have been put in place by the store if they weren't already in place. One of those being the CCTV. So I was contacted by a police officer for an incident that happened further up the street, nothing to do with Cheap Meals or a Cheap Meals customer. But they requested for us to provide them with some of the CCTV imaging, which they believe may have been caught by our cameras. I did provide that to them, and I believe that's actually resulted in a support of their investigation. So there is absolutely no hesitancy at all for us to cooperate with any authority, whether it be the council or the police. And that's very, very important, I believe, because we've been very considerate right from the beginning in that relation.
Thank you, Mr. Akbari. Thank you, Ms. Clover, as well. Thank you for your representations. Okay, I'm going through the agenda now, and I am now going to call the responsible authorities to invite them for questions.
Good morning. Can I speak or?
Yes, please. I've just
Okay.
invited you to speak. Thank you.
Sorry, I wasn't sure if licensing would like to. I just want to go back to Mr. Akbari. So he's made reference to an incident that wasn't related, and I'm glad he made it wasn't related to the premise. I'm glad he made reference to that incident because well, I'll just ask the question. I'll make my representation later. I'll just ask the question. So what was the incident related to, and when was this incident?
I don't have the information available to me at this point.
Do you remember what incident it was? If you've been involved with the police, what exactly happened? If you were asked to provide CCTV?
Chairman, forgive me, I'm not sure this is an appropriate question for an environmental health officer to be asking. If there may be confidentiality disclosure issues about a police incident.
No, No, I have permission from the police to address this, but I'll address that in my representation.
Well,
with
again,
regards.
Sorry,
it's a legal point.
I think I think Ms. Clover is correct. I don't think it's a criminal incident. Can't really be discussed in this context.
Thank you, Alison.
And also it would need to be something that was within the representation regulation 19. You can't introduce new material in the middle of a hearing as something that the police have said outside of the hearing. That wouldn't be proper.
Thank you, Ms. Clover.
Okay, now unfortunately what happened with regards to the police putting a representation, it was a misunderstanding because they assumed it was new premises license application, which we have to deal with, and they haven't done any checks. But further information did came out when it comes to criminal incidents and taking place or linked to this address. That's all.
Madam
and that's
Chairman,
all
I have just made the legal point that it's inappropriate to introduce new information in the middle of the
I haven't mentioned
now
any
just done
incident.
exactly that.
Okay, I haven't made reference to any particular incident.
Mr.
I was
stick to the rules.
See, in the absence of the police being here, I think we need to take that point as read.
Thank you, Alison.
Okay, thank you. Okay, you've made reference that Mr. Yassin contacted me. In fact, I contacted Mr. Yassin, and you've also made reference to Miss Clover. You made reference that you've emailed me. I haven't received any emails from yourselves. I made contact with Mr. Yassin because I wasn't able to get hold of Mr. Akbari. I contacted Mr. Yassin by telephone. I left messages. He wasn't coming back to me. Then I emailed, hence the email chain. And when I contacted Mr. Yassin by telephone, he told me that I shouldn't be speaking with him. He's not in charge of the extract system. And I explained to him that I'm not able to get hold of anyone in charge of that premises. And as he's linked and he's coming from the head
Joan,
office
is this
of
a
Chidmi.
question?
No, that's what I'm asking. I'm asking when did you email me? You've made reference that you emailed me.
Yeah, you emailed my client at 7 o'clock last night, and I responded at 9 o'clock.
And you said I haven't responded to your emails. That's why you've made
No, I
reference
didn't
to.
say you hadn't responded. I said I had emailed you myself.
I haven't received any emails.
Well, I'd be happy to send it again. But the fact is, I sent it and it was
Miss
copied.
Clover, can I ask that you send them again, please, Miss Clover? Thank you. Okay. Are there any other questions to the
And also,
Sorry.
Miss Clover made reference that they requested information and that we haven't provided this information. I'm not really sure what information they requested. Again, I haven't received. I received an email from Mr. Akbari saying that he wants all the information that I have on the file, and that's it. And then I explained to him that I would like to speak. And also there are allegations that I haven't provided a phone number. At the bottom of my email that was sent to Mr. Yassin, there is a telephone number on the signature. So I have never been asked to provide a telephone number. So that's why I want to know who asked me to provide a telephone number, and I refused. I would like clarification on that.
Madam Chairman, I've got the whole email thread. It might take a bit of time to go through it. I don't know how much this helps you. There is a dispute here as to who has contacted whom and when. The emails can be produced. I don't know if Mr. Alam would like to comment on when Mr. was asked to provide a number.
Thank you, Ms. Clover. I was going to ask Yassin Alam to respond to that, please.
No problem. Thank you for giving me the opportunity to speak. I think I want to highlight that as soon as I received the email from Ms. Chupa, I was, by the way, on a holiday in Egypt. Yes, I think it's correct. She called me on a Wednesday with an unknown number. I think I didn't receive the first voicemail. I received the second voicemail, and she followed up with an email. That's absolutely correct. I responded straight away via email, said, I'm sorry.
Cornelia, we can't hear.
Yes, I think Mr.
you can
Yassin
do.
Alam's screen froze. Mr. Alam, can you say something, please?
I think his screen's frozen. Do we
Just give him a moment.
do we want to go off live and have a quick 2 minutes whilst you get the IT systems working?
I think it's for him to maybe exit and come back. Yeah. Perhaps
I think it might be sensible, Chair, just to pause for 5 minutes.
Yeah.
Yes. Can we just pause for 5 minutes, please?
Do you want me to stop the live stream? I think we can just hold on. I'm sure he'll join shortly, because I already had to stop it once earlier and restart it. If we just pause, I think it's okay.
He has confirmed that he's just lost connection and he is trying to rejoin again now.
Okay. Thank you, Sammy. Thank you. I do apologize, everybody, but with IT, these things do happen. It doesn't look like he's going to be joining us. Cornelia, are you in touch with him?
I can send him an email. I'm sure he's trying to join, but I'll send him an email anyway. Or I might phone him if I have a phone number. I'll have a look.
Madam Chairman, I also have contact with him, and he says he's connecting now. So
Okay, thank you, Ms. Clover. Thank you. I was going to say, otherwise we may have to pause.
He's just joining. He's just joining now.
Thank you.
Sorry about that. Can you guys hear me?
Welcome back, Yasin.
Apologies, I lost the connection for some reason.
Yes, we realised. Yes, please, if you can continue.
Sure. I'm not sure if you got from the start, so just really quickly, sum up what I said. Miss Stupa got in touch with me via phone call initially with an unknown number. I missed that call. I'm very busy, usually in a lot of meetings. I didn't get the first voicemail, fair enough. Maybe I missed it. Maybe my bad. She did contact me, I think, a day later again with an unknown number. Where I heard the voicemail, but unfortunately there was no phone number she provided me to call her back. And I think a couple of hours later, she followed with an email where I responded straight away. I said, I'm sorry, I wasn't available. I believe you called with an unknown number, and we have the evidence via email. And I offered to speak the next day at 2 p.m., bearing in mind I was on holiday in Egypt. On that day, 2 p.m., I spoke to her. My assumption was she is going to talk to me about the late night license refreshment application I have put on behalf of the client. That was not the case. She started talking to me about ducting. I said, I am sorry, I'm not entitled to talk about this because clearly this is an unlimited company. I am not in charge. She said to me, well, I'm struggling to get in touch with Mr. Akbari, and I'm going to refuse or object the application for late night refreshment. I did say, well, I'm not a lawyer, but as far as I understand, this doesn't fall within the late license refreshment. Please feel free to put in your representation if you think, you want to put that, but I'm the wrong person. I think we got off to a bad start. I think we both then calmed down. I said, look, I'm trying to help you here. I'll contact Mr. Akbari via email, which I did the following day on a Saturday. I have the email again. I said, Ms. Stupa, thank you for your call. This is Mr. Akbari's email address. Please get in touch with him. Mr. Akbari straight away responded on a Sunday, as far as I remember, said, I think you tried to contact me. Sorry, my father died. Let me know how I can help. I think she then tried to call him directly, and I believe he wasn't in the UK. And again, I was CC'd in all the emails. And she wasn't able to contact him via phone. And he responded, said, I'm sorry, it seems that my phone doesn't work. Can I please call you on WhatsApp, or can you please, message me via email? And unfortunately, since then, that was the last email that was sent out. And again, we have that on evidence. So I think you will see that I think we have no reluctance to work with any authorities. I myself was the one who liaised with the police. We spoke to Mr. Akbari, said, these are the conditions that the police wants to put in place. Are you happy? We said, yes, absolutely fine. I believe Mr. Elliott came in place. And to be honest with you, I mean, I'm the head of operations of 18 stores. Ms. Clover got that initially wrong. We have 18 stores and not 11. I'm the head of operations of all of them. I've attended about 6 hearings so far, and I've always been very supportive and been very cooperative with any authorities. So this is my summary of what has been said so far. Thank you, Chair.
Thank you, Mr. Yasin. Ms. Stupa, did you want to ask another question, or is that okay for now? Otherwise, I'm going to go to Shane if he's got any questions.
No, that's fine. Thank you.
Thank you, Ms. Stupa. Shane Elliott, do you have any questions?
Not at this time, Chair.
Okay, thank you. Right, if that's the case, according to my checklist here, normally it'd be the objector, and in this particular case, we've got the objector is the chair of Walpole Residents Association. I know everybody has already received it, as this is a live feed. Alison, would it be appropriate for me to read this out?
I think that the papers are already on the record and on the web, so that's probably not necessary. I think unless anybody disagrees, I think they can be taken as read.
Okay, thank you. Is that okay, everyone? Thank you. I see the nods. Okay. Questions from councillors. Councillor Ball, please put your mic on.
Yes, thank you, Chair. Yeah, Ms. Clover said that we're not allowed to punish the applicant for opening previously without the to 3 AM without the benefit of the license. But is it not? Does it not? Would you not agree with me that it does go to the point about prevention of crime, that there was an offence committed by the applicants by opening without a license during that period?
No, Chair, it's apples and pears, and you'd have to go into the details of the Section 1 of the Licensing Act. The offence for conducting licensable activities otherwise than in accordance with a licence is Section 136, and that goes down a certain route, and that isn't your remit. You don't have power over that. The magistrates are seized of that. Now, what you can't say is that because somebody wants opened premises without a licence, that must mean that opening with a licence means that the licence will give rise to crime and disorder. The licensable activities will give rise to crime and disorder. So offering hot food and hot drink after 11 o'clock is the licensable activity. It is that which you need to determine in these proceedings, whether that will give rise to crime and disorder that must be prevented. And the fact that somebody once committed an offence, and again, I'd advise or invite you to be very careful about the language used, because you can't say somebody has committed an offence and is guilty. We have a very strong principle in this country of innocent until proven guilty. So that would have to go through the magistrates' court before you could say an offence has been committed. So you have to be very careful to keep those tracks separate. Otherwise, what you're doing is punishing somebody for a crime instead of the magistrates doing it. And your punishment is denying them a licence, which isn't one of the punishments that the Act allows you to give. So it's a double whammy, and that starts to be a public order, a public law problem, and that goes to judicial review, and you don't want to go there.
Thank you, Ms. Clover. Councillor Ball, did you have another question? Because your mic's off and I can't hear.
Oh, no, sorry, no, I didn't have another question. Thank you.
Okay, thank you. Councillor Martin.
Yes, I do. Thank you, Ms. Grover, for your excellent presentation. You say, however, that there are no objections from local residents, but there's also nothing in favour, to be honest. And if there has been quite a lot of communication, correspondence, whatever it may have been, with Cheap Meals and the manager and assistant and director, whoever it may be, I'm a bit sort of surprised, given that there seems to be a lot of around the negativity, and that there's supposed to be objections. There's nothing in favour here. There's a lot of conversation, but I'm not seeing anything in writing. I mean, that can work both ways.
Can I come back on that?
I'll just finish. I'm also a little concerned.
I was going to say, please, Councillor Martin, continue.
Yeah, I'm also a little concerned that, and I take your point over where we go with the law and judicial reviews and so on, but there is an understanding for any business on any high street, when they have an application in and they have opening hours, that ideally they stick to those. I mean, we could be put in a situation across this borough, to be quite honest, where any business across any of our high streets or town centres basically could ignore the law and open, and just, we could have a free-for-all. So I'm sort of just quite keen to sort of just get an idea of how you feel about that, and how Cheap Meals will, in all fairness, probably stick to, you know, if this application was to go through to 3 o'clock, who knows that they might push to 5 o'clock. They might open 24 hours. What assurances are you giving us as a committee that if we were to grant this, that they will stick to it?
Well, dealing with the first question first, the positive representations. I've been doing this job for 30 years, and I would love it if people would take their precious time and randomly write in letters of support for things. People don't do that on TripAdvisor or in planning applications. They don't look at signs on lampposts and in windows and say, yeah, I have nothing particular to do with these premises, but I'm going to write in a random letter of support. I'm going to go home. I'm going to remember that I've seen that advert or that notice on a lamppost, and I'm going to take time out of my day to write a letter saying, I do not object. That never happens. I'd love it. It would be great. It doesn't happen. And you would only really need to access TripAdvisor or social media or responses and comments and so forth in online newspapers or what have you to see the disproportionate ratio of negative comments to positive comments is eye-watering, because people have got much more time to say what they don't like than they have to say what they do like. And it is as simple as that. So perhaps that's just aspirational and wishful thinking that people would write into support, but it cannot and must not be used as any kind of indication that there's something wrong with the application because people haven't written into support. Sometimes people get as far as putting in a petition or a survey, and then everybody goes, but they don't even know what they're signing. They could just be putting a name on a piece of paper, and it doesn't mean anything to them. So you can't win. But positive reps, I wish, is my answer to that. And then opening in advance, I've explained how it's happened here. It's highly regrettable, but it's come as a consequence of a series of unfortunate events. And Mr. Akbari, as the person who you might expect to know the most about what can and cannot be done under licensing law, and at the end of the day he's not a lawyer, was absent with some quite emotional circumstances through the death of his father. And so there was an understanding that because the police had given the situation the thumbs up, they could open already. Now that's quite a unique set of circumstances. It's not going to be replicated in the sense of now we've got the 3 o'clock, that must mean we can open till 5 o'clock. That would be random. And there'd be no basis for it, and it wouldn't be based upon a misunderstanding of anything. What you couldn't do, writing down your reasons in your decision, is to say, well, because the premise is misunderstood and they open till 3 o'clock, we believe that they will commit offences in the future and open till 5 o'clock, and for that reason we're going to refuse. And again, it comes back to the same problem I was outlining for Councillor Ball, that you're acting as judge and jury on elements that you have no remit over. What you must do in accordance with the Act is look at the terms of the application and decide what impact they may or may not have on the licensing objectives. That is all that you can do.
Okay, thank you, Mrs. Clover.
Yeah.
Thank you. Are there any other questions, councillors, before okay, thank you very much. Right, I'm now going to invite the noise nuisance team. Who's going to go first?
I'm happy to go first. Thank you, Chair.
Thank you, Mr.
Thank you. Just give me 1 second. Okay, so I'd like to address the fact that it seems like Ms. Clover and Mr. Yassin have concentrated on the fact that I've made that reference in my representation about the noise nuisance, and I did specify that will be addressed.
The screen is frozen.
Can you hear me?
We've not been able to hear a word.
I know, I can see her, so it might be a problem at your end, Chair.
Can you hear me now?
Yes.
Okay. You haven't heard anything what I said?
No, we didn't hear anything. Sorry.
Okay. Okay, that's fine. I was saying that I would like to address what Ms. Clover and Ms. Yassin seems to do. They concentrated on the fact that I've mentioned about the noise nuisance in my representation, and I did clarify that in my representation that will be addressed under the Environmental Protection Act 1990, and I'm not using this as an opportunity. It was only trying to show that the management of this place, it hasn't been engaging with the council apart from the visit that I've made back in July when I spoke with Mr. Akbari, and when I recommended him and I told him what the issue was, and after that I was not able to get in touch with him at all. I've called the shop twice. I've arranged for on two occasions for officers to go to the premises and establish who's running the place. And in my opinion, that's my concern. If we've contacted the premises 4 times, and members of staff were not able to give me a contact detail or the person in charge. And I appreciate that Mr. Akbari was out of the country, but who's running the place? Who's operating that place whilst he's outside of the country? And that's to me shows poor management. And when we had issues with the noise and I was trying to get hold, I could have just served a notice. I could have just served a legal notice and that's it. But as I said, I was only trying to show poor management, and that's all. With regards to, give me 1 second. And also, I would like to add that when I spoke with Mr. Yassin, as he said, we spoke on a Friday. Even after speaking with him, I appreciate that he doesn't he's not the manager of that shop. I only made contact with him to be able to make contact with Mr. Akbari. I specifically said to Mr. Yassin, they're still operating until 3 o'clock in the morning. They need to, and we're still receiving complaints with regards to the noise nuisance, and I was trying to address both noise nuisance and also after my conversation with Shane from the licensing team, I did say to him that I will mention that our officers have witnessed, because we were also making a noise assessment with regards to the noise from the extract system. So I've explained to Ms. Shane. Now I will also mention to Mr. Yassin that they're still operating. So even after my conversation on a Friday afternoon with Mr. Yassin, they carried on operating on Friday and Saturday. And it was also because of the noise nuisance, because the residents were not able to sleep, because now it's better because of the winter month, because it's colder, so they can close the winter with the windows. But it was quite warm in some days, and I think it was September. The residents were not able to open the windows. But yeah, that's all I just wanted. It was mainly to show that the poor engagement that they had with the council and the poor management, and my concern that I don't know who runs the premises whilst Mr. Akbari is out of the country. But as I said, the noise nuisance will be addressed under a different legislation, and we will serve a legal notice for that to be addressed.
Okay, thank you, Mr.
That's all for me. Thank you.
Thank you very much. Mr. Elliott, is there anything you wanted to add?
No. I'm going to make my representation. Is that okay?
Yes, please do.
Yeah, sure. My representation is based on reports from Noise and Nuisance team, as Mimi has already said, regarding them trading beyond licensable hours. So I was first alerted in August of this occurring, and I visited the store 1 or 2 occasions, and as similar to Mimi, the members of staff couldn't give me they gave me a contact number for Sammy, but I couldn't get a hold of Sammy. So I couldn't get a hold of a member of staff, and the member of staff in the premises couldn't get a hold of anyone. So that was a concern from the beginning. So a few weeks passed, and Sammy contacted me, and he gave me a call, and he said that he apologized. He said he's been a bereavement, and he's been out of the country, which I completely understood. He's going through bereavement. However, if he's out of the country, who's the point of contact when he is out of the country? So that was my concern, and so he said, oh, okay. Sorry, I'm just looking here. So yeah, he said yes. That they have been trading past last couple hours, and they're going to make an application. And as already mentioned before, there was confusion within the licensing team regarding what application to submit, and it did lengthen the process. But however, as mentioned, that they have been trading continuously past 11 o'clock, all the way up until where I made my representation on the 13th, or the closing date for representation, where I emailed Yassine to say that there's been further reports of them trading beyond licensable hours. And only then I received the email on the 16th of October to say that they've changed the delivery times on delivery platforms, and they're no longer trading past 11 o'clock. So my representation was based on the confidence that they were going to be sticking to the hours, as Councillor John Martin already mentioned. And to address what Ms. Clover mentioned earlier in her representation, that them trading past licensable hours is actually a positive. To counteract that, I think it will set a precedent for other premises to put in an application, and then regardless of what the application says or what it says on the application, they could trade to whatever hours they want. And I just don't think it sets a good precedent for other applications to do this. And also, I want to take everyone's attention to page 14 of the agenda, and it says on that it says current opening hours are from 12 midday to 11. So they put on that application form that their hours is from 12 midday to 11, but yet they've been trading until 3 a.m., which is at the minimum is deceitful if you're putting down an application, but you're doing something else. So that's so that's why I put in a representation, because if I'm continuously emailing and trying to get a hold of them to let them know that they are trading, but they're doing regardless of what they want to do anyway, it just doesn't set a good precedent, and it shows the communication, or it shows a disregard for authority. So that's my representation.
Thank you, Mr. Elliott. Ms. Clover, do you have any questions for them?
I don't have questions, Madam Chairman. I'll make some closing submissions if I'm permitted to, please, about these points. Okay, thank you.
Any questions from our panel, Councillor Ball?
Yes. So for Shane, could you just clarify the total length of time that they were opening, as far as you're aware, that they were opening until 3 a.m.?
Sure. I was made aware in August by Mimi's team, so it was on the 16th of August. No, sorry, let me get the correct date. I believe it was on the. Sorry, it was in August. I can say that. I can't get the time. I can't get the exact date right now. And then I emailed Cheat Mills to say that they've been trading past last hours. And as far as I know, all the way up until after the application for the premises license was closed, they've been traded up until past 11, as far as I'm aware.
Sorry, so what's that? So in terms of kind of, so that was, when was that? When did it close?
That was on the 13th. So the application, so the 13th of October. Sorry. So from August, I was first made aware until the 13th of October, when the premises license application was finished.
Okay, thank you.
Sorry, can I add something? Can you hear me? I'm having some issues with my Zoom.
Yes.
From my understanding from the resident, it was from around April. That's when they're operating until. But I mean, I'm sure Mr. Akbari can clarify that, because when I visited Mr. Akbari back in,
I'm going to ask to jump in, please.
In July.
I made the point earlier that I mustn't be ambushed, Regulation 18, by material that is coming in the middle of a hearing that hasn't been disclosed previously. I don't know anything about conversations between Ms. Stupu and a resident and April. She's not permitted to do this, and I'm taking a legal point.
I'm not adding it. I'm not adding that. I said Mr. Akbari could clarify when he first opened, because when I met Mr. Akbari on site back in July, he did confirm to me that they're operating until 3:30. So I'm sure he would be able to
I'm running
clarify
the case,
from the
I'm running the case for Mr. Akbari, and I'm making the legal point through the legal advisor to the chairman on this. It's not appropriate.
Alison, please come in.
Well, yes. I mean, if it's a new piece of evidence, then no, unless with the agreement of all parties, it can't be considered. It would need to be all parties would need to be made aware of something substantive like that.
Thank you.
I appreciate that. I appreciate that, but as I said, in my representation, it does state that that's not new information, that Mr. Akbari confirmed to me back in July that he was operating until 3 o'clock in the morning. It's within my representation. Thank you.
Thank you. Councillor Martin, do you have any questions?
No, I'm okay, Chair. Thank you.
Okay. Thank you. If there are no more questions.
No further questions from me.
Right, if that's the case, can I ask Ms. Clover to sum up, please?
Madam Chairman, I would usually get last word after the summings up of the objectors.
Are there any other objections, any other comments?
No.
Okay, I'm following the agenda here. If there are no others, then Ms. Clover, over to you.
Thank you. I've just got a few comments. I won't be going through everything all over again, as you'll be pleased to hear. In looking at this business of what you can or could or should do about previous trading out of hours, I've said quite a lot about that, and I stand by it from a legal point of view. But don't forget also the correspondence with the licensing authority that said in terms that they had a license already. Now, that was wrong. That was misinformation. They were told that they needed to make a minor variation to the license that they've already got. And we've got that correspondence, and that should be taken into consideration as well.
Excuse me, Ms. Clover. Ms. Stupu from the noise nuisance teams appears to have dropped out of the call. If we could just pause, and I'll find out if she plans to rejoin.
I was wondering what had happened there. Okay, thank you, Cornelia. Ms. Clover, if you can just please pause for a moment. Thank you.
She's just joining now.
It's just joining, yeah.
Okay. Okay, with the chair's permission, Ms. Clover, I think you can continue. Ms. Stupu, we paused when you dropped out. Just to let you know.
Are you happy for me to continue, Madam
Yes, please continue, Ms. Clover.
Thank you very much indeed. So I was just making the comment that the licensing department, and it's all inadvertent, it's not a criticism, other than it has confused matters somewhat. So they were told that they already had a license, and then they were told that they did not. The question's been asked, well, what makes us think that they will now stick to their hours? Well, firstly, the licensing authority has got the same powers now that they've had all along, which is to take action through a different route of the Licensing Act 2003. If people are conducting licensable activities without permission, it's not something that this committee can do, but there are powers within the Licensing Act 2003. So it's not as though there's nothing anybody can do about it, but I would highlight the fact that the application that they want is till 3 o'clock. So it's rather counterintuitive to say that they've made an application till 3 when they could have made an application till 5 if that was what they really wanted, and then they'll do the extra few hours surreptitiously. Why would they do that? If they wanted longer and you're worried that they might continue to trade longer, that is what the application would have said. So the misunderstanding, the miscommunication, the misdemeanor, if you want to go that far with it, is over. It is complete. It's the end of it. The council still got the powers that it's got if it chooses so to use them, but it's not something that can or should be resolved in a licensing decision like this. And don't forget too that although the premises, the applicant jumped the gun after liaising with the police on the hours, they also jumped the gun on the conditions. So they are responsible in that sense, that they thought they were entitled to continue to trade, at least after the police had engaged with them, and then they implemented those conditions commensurately with the hours in accordance with the police wishes, and that needs to be taken into consideration as well. Mr. Elliott calls the premises deceitful. Well, that's unfair. There's different arms of the business making the application. Mr. Alam is making the application in his office. He wouldn't necessarily know what is going on the ground. He doesn't live in Ealing or outside the premises. So to say that was a deliberate deceit is over-egging the pudding unacceptably. And he also says it will set a precedent. Well, the first question there is, how would anybody ever know that the premises were trading without a license? They'd have to go trawling through the licensing register to see what hours cheap meals had and whether they were exceeding those hours and whether they were doing it surreptitiously. That isn't going to happen. So that's unrealistic. It's not a precedent, but in any event, in licensing as in planning, a precedent is not a licensing objective. It's not a planning objective. It's not a reason to put down on a licensing decision to say we're refusing the license in case it causes a precedent for somebody in the future to exceed their licensing conditions. If that popped up on a licensing decision, that would have to go straight off at the very least for an appeal. And as I said, it could be more. Ms. Stupu says her point is not a noise nuisance point. That's correct, because it's under the Environmental Protection Act 1990. She says it's about poor management and lack of engagement. Well, that's a two-way street, as I hope I've made very plain. And there have been a number of requests for the noise readings, which we haven't had, the file notes, which we haven't had, and haven't had any response to that request for the file notes. And I'll have to Freedom of Information Act it if I must. But it goes two ways in terms of the communication. And I hope, having heard Mr. Alam and Mr. Akbari, that it's not quite, you accept it's not quite the picture that was originally presented, which was that everybody had gone to ground, which is what you could have understood from the written representations, and nobody was engaging whatsoever. It's more nuanced and confused than that at a time over the summer when people were either on holiday or, very regrettably, Mr. Akbari had suffered his bereavement. Those are not circumstances that are likely to be repeated. The officers say, well, if Mr. Akbari is away, who do we contact? The answer is Mr. Alam, or if they really want to, me. And then finally, I'd like to finish on a positive note, if I may, because there's been quite a lot of negativity, but actually this application is a positive for the local economy and for local employment and local contributions to rates and taxes and so on at a very difficult time, a cost of living crisis, when people need their jobs, and they also need access to the facilities that they want to use, and encouraging small local businesses will also be something that the council will have numerous policies about that they will want to support. Those are licensing considerations, and I speak advisedly on that because it's not me saying so, it's Lord Justice Toulson that says that at paragraph 42 of the Court of Appeal case of Hope and Glory. And in that case, he sets out a range of relevant considerations for a licensing decision maker. And key amongst those is the stimulation of the local economy, the financial benefit to the licensee that is something that he says is relevant. Sometimes officers forget that, as well as the impact on people living and working in the vicinity. Now, for all of those reasons, this is a positive application. You have all the powers that you need to curtail it in the future if you wish to do so, either by taking action against the individuals or by reviewing the application.
Councillor Martin's dropped off, hasn't he?
Oh, so sorry. I'll stop. I have nearly finished, actually, but...
Apologies, Ms. Clover. Cornelia, are you in touch with Councillor Martin?
I haven't been, because I'm sure he's going to be trying to log back in, but I can try to message him. Thank you.
Apologies for the pause again. It's due to IT, I'm afraid.
Back to in-person hearings.
He says he's trying to join, so please, if we could just be a bit patient. Thank you.
Apologies again for the disruption. Amelia, I'm just wondering, do we need to pause or?
No, Councillor Martin's just joining us now.
Councillor Martin, are you with us?
Thank you very much. I have no idea what happened there.
Same thing happened to me earlier, so I totally understand. Right, okay, we are still live. Miss Clover, I know you were about to end your summing up, but if you can continue, please.
Thank you. And it was just that final point that the council's got all the powers that it needs. If it needed to intervene or change this licence or even withdraw it completely, you've got the power of review. And your officers have got further powers as well if they feel that there is ongoing lack of cooperation. I firmly refute that that will be the case, but if I'm wrong about that, your officers have got all the powers that they need to deal with it, and that is why licensing is required to be a light touch regime, a permissive regime that says yes in the first instance unless there is clear evidence to the contrary, in the secure knowledge that you can review and change and withdraw in the future should that become necessary to do so. And I hope and trust that you would find on this occasion that it would not be necessary. So unless I can assist you, that's what I wished to say.
Thank you, Ms. Clover. Right, if that is the case, we are now going to be deliberating. So basically, the panel will retire to deliberate together with our legal advisor and our clerk, and will take some time. I can't say exactly how long. I know initially we said 1:30, but I believe it may be a little sooner. So if you can all be on your guard, I think the sooner we can complete this, it'd be better. So if Cornelia, if you can end the live feed and we can retire?
Yes, Chair. Perhaps we can give a guideline, maybe 1:15 to when.
1:15, yes, 1:15 sounds good.
Okay, for the parties